Woke gets judicial protection. Let groundbreaking continue for the parallel society. But watch out for the judicial bulldozers that the woke society will send. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Last Friday, August the 19th, a federal judge effectively gave woke the special protection of the judiciary. He enjoined the workplace training part of the Stop Wrongs to Our Kids and Employees Act, or Stop Woke Act. Governor Ron DeSantis of Florida signed this into law in December of 2021. Now, Judge Mark E. Walker says this law violates the First Amendment protections of those who tell employees that normal and professional are white racist words. With this ruling, Judge Walker gave another push to those seeking to build parallel structures in the United States today. But his judicial history suggests that one of his next rulings will be that departments of and consultants to human resources would be derelict in their duties not to tell whites that they are inherently racist. Before we get into details, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, including this t-shirt that I have chosen for today. It shows a man in a hood and these words: "If fascism ever comes to America, then it will come in the name of liberalism." Unquote, Ronald Reagan from 1975. Now, before we get to the ruling, let's look at what the Stop Woke Act, also known as the Individual Freedom Act, actually does. It targets two bad influences: teachers, boards of education, and others who promote woke ideology in school, and departments of and consultants in human resources who similarly promote woke ideology at work. The formal term for woke ideology is critical theory. The idea goes by other formal names like critical race theory, intersectional feminism, and queer theory. Essentially, woke ideology assigns social credit to members of certain identity groups. The credit has its basis in a new wrinkle on the communist theory of history. The original communist theory of history emphasized class struggle. The woke theory emphasizes a struggle among races, between the genders, and between and among normal and alternative lifestyle choices and adaptations to stress. This should surprise no one. The social credit score for a white, heterosexual, cisgendered male is 0. Governor DeSantis complained of consultants in both human resources and educational psychology doing two things. First, they convinced their clients that equity demands placing these 0 social credit individuals at a disadvantage and subjecting them to continual emotional torque at work and in school. Second, they charge hefty fees for their dubious services. The Stop Woke Act forbids the promotion of woke ideology at work or in school. Critical race theory is the target getting all the attention, but not by far the only manifestation of woke. And parents can sue schools who teach woke in class. And until Friday, HR departments could not teach woke at work. All right, for those of you scratching your heads and asking social what, or cis what, or even what's an injunction, let the definition section begin. First, you all know about the use of the word WOKE as a new adjective or passive participle instead of a simple past tense. Beyond that, I'm going to define a few other words that I've already used and am going to use. Intersectional. That's a woke concept saying that a woman is like a hapless pedestrian in the middle of a dangerous road intersection where bigots and bullies can hit her from all directions for being a woman, for being non-white, blah, blah, etc. ad nauseam. Cisgendered. identifying as a member of the gender of one's birth, from the Latin preposition cis, meaning on the same side of the line, opposite to transgender, which means crossing the gender line. Human Resources, abbreviated HR, that department dealing with hiring, benefit management, tax payments, on and on and on. Employers used to call this department personnel. Social credit, a method of scoring individuals from membership in certain victim or oppressor groups. The Chinese Communist Party invented the concept and they use it today. Diversity training, specific training ostensibly in encouraging all staff to respect the feelings of other staff and all pupils to respect the feelings of other pupils. Now, if this training limited itself to discouraging the telling of off-color and similarly boorish jokes, Governor DeSantis would not object, neither would I. But modern diversity training actually says that words like normal and professional are white racist words. It also teaches core woke tenets. Racist becomes identical to white, sexist to male, and so on. Injunction, a court order to someone to stop doing something or to start doing something. To enjoin someone means to issue an injunction against him. We turn now to the ruling in honeyfund.com versus DeSantis, case number 4:22 CV 227 MW/MAF. In the United States District Court for the Northern District of Florida, Tallahassee Division, Judge Mark E. Walker presiding. I have left a link in the description to where you can view and download the PDF of the ruling from a service I know well. It calls itself Document Cloud. Now, in his ruling, Judge Walker actually invokes a television show called Stranger Things, available on Netflix. Here's how he begins. In the popular television series Stranger Things, the Upside Down describes a parallel dimension containing a distorted version of our world. See Stranger Things, Netflix 2022. Recently, Florida has seemed like a First Amendment upside down. Normally, the First Amendment bars the state from burdening speech while private actors may burden speech freely. But in Florida, the First Amendment apparently bars the private actors from burdening speech while the state may burden speech freely. Now, like the heroine in Stranger Things, this court is once again asked to pull Florida back from the upside down. Now, the once again phrase refers to an earlier ruling by another judge of the same district court. In Net Choice LLC versus Moody, Judge Robert Hinkle blocked a Florida anti-deplatforming law. The ruling is on appeal to the Court of Appeals for the 11th Judicial Circuit. But obviously that ruling destroys the common carrier doctrine that had been a key feature of American commercial law. Anyone wanting to know the reason for platforms like Gab.com or TruthSocial.com will find it in this ruling. I have left links in the description to both. The Stop Woke Act says teaching any of the following constitutes racial, sexual, or other discrimination. Let's call these the 8 Precepts of Woke. They read as follows. 1. Members of one race, color, sex, or national origin are morally superior to members of another race, color, sex, or national origin. 2. An individual, by virtue of his or her race, color, sex, or national origin, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. 3. An individual's moral character or status as either privileged or oppressed is necessarily determined by his or her race, color, sex, or national origin. 4. Members of one race, color, sex, or national origin cannot and should not attempt to treat others without respect to race, color, sex, or national origin. 5. An individual, by virtue of his or her race, color, sex, or national origin, bears responsibility for or should be discriminated against or receive adverse treatment because of actions committed in the past by other members of the same race, color, sex, or national origin. 6. An individual, by virtue of his or her race, color, sex, or national origin, should be discriminated against or receive adverse treatment to achieve diversity, equity, or inclusion. 7. An individual, by virtue of his or her race, color, sexual, national origin, bears personal responsibility for and must feel guilt, anguish, or other forms of psychological distress because of actions in which the individual played no part committed in the past by other members of the same race, color, sex, or national origin. 8. Such virtues as merit, excellence, hard work, fairness, neutrality, objectivity, and racial color blindedness are racist or sexist or were created by members of a particular race, color, sex, or national origin to oppress members of another race, color, sex, or national origin. Now, in case you've been living under a rock, those who promote these concepts apply them selectively, which means members of any race, color, sex, or national origin other than Caucasians, whites, males, or born Americans are in fact morally superior to Caucasians, whites, usually the same thing, males, and born Americans. Once you grasp that, that explains every other precept and how it works. Now, I have to get into what Judge Walker's ruling really means. Before I get into it, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is OurSilverLines.com. Do you feel like you've been working very hard for your money just to get by? You're not alone. Not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, OurSilverLines.com can help you learn to lead an exceptional life. Visit OurSilverLines.com to learn how you can build a legacy for your future. Well, Judge Walker specifically says that employers and consultants may indeed endorse these 8 concepts or 8 precepts of woke in all their selectivity. When he does that, he insists that the Stop Woke Act regulates speech and only incidentally regulates conduct. That, he says, violates the First Amendment. In fact, Judge Walker says flatly that America is still an inherently racist society. How else can you interpret this? If Florida truly believes we live in a post-racial society, then let it make its case. But it cannot win the argument by muzzling its opponents, because without justification, the law attacks ideas. Now, to illustrate the point further, he includes this, and I urge you to follow the document cloud link. Seeing is believing. Scroll down to page 43, just before the orders. Quote, telling your employees that concepts such as normal or professional are imbued with historically based racial biases is not, and it pains this court to have to say this, the same as trapping black employees in a room while a woman in a gorilla suit puts on a retaliatory, racially inflammatory performance the day before a holiday celebrating the end of slavery. Rather, it is speech protected by the First Amendment. In point of fact, no internet engine search has produced a single reference to any case of anyone putting on such a disgusting and puerile display at work, or of management tolerating it. So already, this judge introduces a comparison for which he has laid no foundation. Worse than that, he ignores the effect of endorsement of the forbidden concepts would have. Examine this paragraph from the Honey Fund ruling. Page 26. Defendants also place a great deal of weight on the first concept, that members of one race, sex, or national origin, race, color, sex, or national origin are morally superior to members of another race, color, sex, or national origin. Who could object to banning that? Of course, the IFA bans much more, such as suggesting that white privilege exists, concept 3, or that people should consider another person's race or sex when interacting with them, concept 4. In other words, even assuming some concepts are proscribable, which they are not, the IFA still prohibits the endorsement of many widely accepted ideas. Now again, the judge fails to establish any wide acceptance of the white privilege and other woke ideas, nor would that be relevant. A wrong idea with wide acceptance is still wrong. Furthermore, concepts 3 and 4 imply concept 1, which he already admitted that it could be banned. The judge also fails to acknowledge who is speaking. Now, here in plain non-legislative-ese English is what the 8 concepts of woke boil down to. 1. Non-whites are morally superior to whites. 2. Racist is identical to white and sexist identical to male, on and on and on. 3. Whites have privilege and non-whites suffer oppression by definition. 4. Color blindness is repugnant in and of itself. 5. Whites must suffer to redress wrongs that whites committed in the past. 6. Whites must suffer to even the score with non-whites. That's the meaning of equity. 7. A white, or male, or heterosexual, or whatever, is personally guilty of all past sins of whites, males, on and on and on. And last, merit, excellence, hard work, fairness, neutrality, objectivity, and colorblindness are all white, racist, male, sexist, and other ist words. Now, when any ordinary fellow worker, not your supervisor, comes to you and starts haranguing you with that kind of nonsense, it's easy to walk away from him and say to yourself, he's just being a jerk. I'll pay him no mind. Never mind the female equivalent. That's not kosher. But when your supervisor says it, or worse, the dreaded HR says it, then whoever is speaking has just told you to expect lower pay, deliberately demeaning assignments, and various shove-asides. That's conduct, Your Honor, and your failure to recognize that constitutes the worst sort of judicial error, except for Roe versus Wade, and Plessy versus Ferguson, and Dred Scott versus Sanford, which reminds me, Clarence Thomas just got finished tearing the leftist side to little pieces over the parallels between certain laws he and his colleagues just got finished striking down and the Dred Scott case. I can't wait for Mr. Justice Thomas to sink his teeth into the likely verdict in the Honey Fund case. Judge Walker does say that the actual implementation of lower pay, demeaning assignments, and shove-asides would violate the Florida Civil Rights Act. But why permit the dreaded HR to threaten such conduct if it's illegal? Since when do threats of illegal acts constitute protected speech? Hey, last I heard, if you tell somebody that you or any third party ought to beat them up, that's a threat. Not a court in the land will allow that, or didn't before last week. Now, to understand the ruling of Judge Walker and the earlier ruling of Judge Hinkle, you have to look at their respective histories. So let's ask. To paraphrase Jack Nicholson as Colonel Nathan Jessup, USMC, in A Few Good Men, Whiskey Tango Foxtrot are Mark E. Walker and Robert Hinkle. Walker first. Barack Obama appointed Judge Walker to the court in 2012. His Wikipedia page, at least as of this posting, lists his most notable rulings. Without exception, these are woke rulings. In the Mark Walker world, felons, or at least ex-cons, may vote. Automatically, the state must permit early voting and drop-box voting with all the security problems they bring. Riots are First Amendment protected speech. In fact, Florida is such a horrible suppressor of votes that it must pre-clear all election laws with the federal government. Now, the 11th Circuit enjoined that one, which is still on appeal. Now, Judge Hinkle is almost as bad. Bill Clinton appointed him in 1996. His Wikipedia page, as of today, lists 3 big rulings, one of which the 11th Circuit reversed. He is a senior judge now, meaning semi-retired. Bottom line, Republicans must strive to capture a majority in the House and 2/3 of the Senate. They then can clean out the national judiciary and remove many judges from the bench on impeachment for and conviction of infidelity to the Constitution. Judges Walker and Hinkle would ipso facto be the perfect candidates. In Judge Hinkle's case, impeachment would mean forbidding him to take any more cases. But these things take time. So the question for us, opponents of woke, is what do we do next? Well, so far, those parts of the Stop Woke Act applicable to school lessons and parents' right of discovery and cause of action are still in force. They will stay in force until some teacher sues to say that she has a right to tell her white pupils that the school ought to make rules that they sit in the back of the classroom or on the school bus, stand last in line, eat prison food while their non-white counterparts get the good food, on and on and on. So long as the school does not actually make or enforce such rules, teachers may say what they like. Well, that hasn't happened yet, but it's now waiting to happen. No doubt Judge Walker stands ready to invalidate the first parental lawsuit against woke teaching in class, and the first pupil to act on critical theory concepts on the play yard, and I'll let you guess how, can rely on Judge Walker for protection. No doubt the state of Florida will appeal the injunction. What the 11th Circuit will do, we'll just have to wait and see. In the meantime, the parallel society will expand to include employers who reject woke ideology. These employers will refuse to teach the 8 Precepts of Woke. And then some member of an aggrieved group will apply for a job with one of these employers, get the job, and then sue the employer for not subjecting white heterosexual cisgender males to such mandatory training. If Judge Walker follows his logic in Honey Fund, he will fine against that employer and enjoin him to institute such mandatory training. Now, I can hear the denials already. I can also hear some, probably not my subscribers, but maybe anyone else who plays this video, even by accident, saying, "What does that white, heterosexual, cisgendered male know about oppression? Check your privilege." All right. Let me remind all my listeners, and all with whom any listener might share my video or channel, that this channel has an open comment policy, or at least a policy as open as YouTube will allow. Anyone may comment as long as you don't threaten or advocate force or violence or use language of such caliber that Thomas Bowdler would have to strike it. Now, before you ask Thomas who, Thomas Bowdler produced editions of classical works which he sanitized to get rid of lewd, obscene, or lascivious language. Today, to Bowdlerize means to censor speech or other conduct according to Thomas Bowdler's original criteria, or any criteria. Of course, that creates a problem, doesn't it? Do any of you expect me to allow woke language but not its equally repugnant opposite? I don't allow comments that disparage non-whites, or whites either. Save for women versus men or any other pairing. But maybe in this particular context, I'm going to have to make an exception, aren't I? Well, let's just say that I will allow comments by any party or friend of the court briefer in Honeyland versus DeSantis, any attorney representing the same, anyone representing himself as an expert in constitutional law, or anyone else among you, if you think you're qualified to comment on the ruling or the Stop Woke Act in support or dispute of any point I have made in this video. The bother and anti-violence rules shall apply, but maybe I'll have to cut you a break on the disparagement rules if you think that you can make a truth claim in favor of any of the 8 precepts of woke, with a clear understanding that I will be ready to rebut any such claims and allow others to do so. Link in the description of the article to the ruling, to Gab and Truth Social, and to Conservative News and Views. I've also left a link to the awesome CNAV Store and to ourcivilines.com, as I also mentioned. And if you like what you've heard, you can like this video. On the end screen, I'm going to leave a subscribe channel and also links to some other videos on rulings by the Supreme Court in its 2021 term that will give you a taste of how it might rule when it finally gets this case. This is Terry A. Hobart delivering another declaration of truth and reminding you to let the truth set you free.